race, color, or previous condition of servitude.
Dr. Anderson, how did people respond to Black people gaining the right to vote?
The response was violence, just violence rained down on the Black community. You had massacres, you had intimidation at the polls, and up through the Mississippi Plan of 1890 is where you get a congealing of the policies to figure out how do we stop Black people, how does the South stop Black people from voting?
Dr. Anderson, given your research, what contributed to such a strong reaction to Black men gaining the right to vote?
My research shows that there was a fear of Black electoral power. There was the language about Negro domination and Negro rule, and how that would undermine the ways of the South. It would undermine the racial hierarchy that had been there since the 17th century.
Dr. Anderson, was there a strong reaction in North Carolina at this time as well?
Oh, yes. There was massive violence that rained down in North Carolina in the early 1870s.
Dr. Anderson, you mentioned the Mississippi Plan. What is the Mississippi Plan?
The Mississippi Plan is where the state of Mississippi rewrote its constitution in order to eliminate Black people from the, access to the ballot box. And it put in place a series of voter suppression, voter disfranchisement mechanisms, such as the poll tax and the literacy test, and some other mechanisms that were targeted at using the legacies of slavery as a means to block African Americans from having access to the ballot box. And they used the legacies of slavery because the 15th Amendment said you could not write a law that says we don't want Black people to vote. And so they use those legacies as the proxy for the way to block Black people from the ballot box.
And Dr. Anderson, what were the effects of these devices on Black voters?
Devastating to the franchise. In 1890, there were 190,000 Black men registered to vote in Mississippi. By 1892, there were only 8,600.
And so how did these devices lead to mass disenfranchisement of Black voters?
It was by using those legacies of slavery. So the way that the poll tax worked was that it used wealthlessness. It used the lack of access to income, to wealth, by saying you have to pay in order to vote. And that built upon having centuries of unpaid labor via slavery, followed by the Black codes coming out of the Civil War, then followed by sharecropping. And so what the poll tax did is the poll tax required, in essence, somewhere between 2 to 6% of a Black Mississippi farm family's annual income to be able to vote.
And Dr. Anderson, you mentioned the literacy test. How did the literacy test lead to mass disenfranchisement of Black voters?
The way that the literacy test worked was that it said, and it sounded reasonable on its surface. It said, well, we want an informed electorate. We want the folks who are voting to know the laws and the value systems of this great nation. And so they should be able to read a section of the Constitution and interpret it back. But what that meant then was that from slavery, again, the legacies of slavery, during slavery, the enslaved were forbidden from being able to read. They were killed, they were tortured, they were beaten if they learned how to read. And then coming out of the Civil War, you had massively disproportionate funding, underfunding of Black schools. And so you had built-in illiteracy. And so requiring people who had dealt with centuries of not being able to read, being beaten or killed for trying to learn, for trying to read. You're now requiring them to interpret sections of the read and interpret sections of the Constitution.
Dr. Anderson, you mentioned the poll tax and literacy test. Were these devices utilized in North Carolina?
Yes, they were.
Dr. Anderson, do we still have the devices such as the literacy test and poll tax? Do we still have those devices today?
No, we don't. The literacy test was banned in the Voting Rights Act of 1965, and the poll tax was banned in a constitutional amendment.
Dr. Anderson, you mentioned the Voting Rights Act of 1965. What did that act do?
That act was a preemptive strike against implementing laws that targeted African Americans' right to vote. And what I mean by that is prior to that time, so like with the 1957 Civil Rights Act, you had where the Department of Justice now had the ability to sue, but that constant litigation wasn't breaking through the massive disfranchisement that was happening in the South. And so you had areas where there were only, say, 5%, 6% of African Americans registered to vote. What the Voting Rights Act did was to say that states and jurisdictions that had a history of discriminating against its citizenry. And so it looked at that in terms of, do you have 50% registered or 50% turnout in the 1964 election? And do you use one of these disfranchising devices? And if you did, then you came up with under what is called pre-clearance, which meant that any law dealing with elections and voting had to go before the Department of Justice or before the courts, the federal courts in DC, to get approved before it got implemented. And that was a way of stopping these laws from cauterizing the electorate and allowing elections and policymakers to rise to the fore based on disfranchising laws.
Dr. Anderson, what was the effect of preclearance?
It was a game changer. In Mississippi, you had Black registered voters were in the single digits, somewhere between 5 to 6 or 7% by 1964, 65. By 1967, 2 years later, almost 60% of Black adults were registered to vote in Mississippi. That was the power of the Voting Rights Act and preclearance.
Dr. Anderson, was North Carolina under preclearance?
There were 40 counties in North Carolina that came under the preclearance jurisdiction of Section 4, Section 5.
And are any states still under preclearance today?
No, the U.S. Supreme Court Shelby County v. Holder decision gutted Section 4, which was the standard that put jurisdictions under preclearance.
And given Shelby County and given your research, how did states respond to Shelby County?
States that had been under preclearance really just unleashed a series of voter suppression laws against Black voters.
What types of voter suppression laws?
Voter ID laws, poll closures, massive voter roll purges, extreme partisan gerrymandering, a whole series of these initiatives that they put in place. Eliminating early voting, days in early voting, all of those kinds of measures targeted at the Black population.
Were any of those measures utilized in North Carolina?
Yes, yes. In HB 589, the state passed a law that had voter ID, that had eliminating some days, key days in early voting, that also went after pre-registration of 16 and 17-year-olds, and that dealt with these poll closures and these other measures coming out of HB 589.
Was HB 589 ever challenged?
Yes, it was challenged in the courts, and the Fourth Circuit ruled that North Carolina had targeted African Americans with almost surgical precision.
Dr. Anderson, presently, Are you currently studying or observing any new forms of voter suppression?
Yes, I'm in Georgia, and Georgia has passed SB 202, which is an omnibus bill that is targeted at that massive voter turnout, Black voter turnout that happened in the 2020 election.
Dr. Anderson, in your research, was there a particular point in history where North Carolina decided to intentionally disenfranchise Black voters?
It becomes really intense during the rise of Jim Crow, because Jim Crow was really about disfranchising and setting up a rule of law that was separate and unequal. And so after the coup in Wilmington in 1898 that overthrew what they called a fusionist government, in 1899, you had the Act to Regulate Elections that had a series of disfranchising measures in there. That was followed by the constitutional amendments in 1900. Those constitutional amendments included the poll tax, the literacy test, and the grandfather clause.
Dr. Anderson, how does North Carolina's use of the poll tax and literacy test and grandfather clause compare with other Southern states?
It's right in line with those other Southern states in terms of requiring payment, in terms of requiring a level of literacy, in terms of the caprice of the registrar at one point. And then one of the things that you saw when the literacy test was challenged in the 1950s, North Carolina did what I call a just so tweak. And that just so tweak was to eliminate the caprice of the registrar in the literacy test, but maintaining the foundation of the literacy test so that it could get through a judicial review, which it did in the Lassiter decision in 1959.
And what was the effect of the poll tax and literacy test on Black voters in North Carolina?
Uh, Black voter registration plummeted. It plummeted.
Dr. Anderson, what explains this result? Why did Black registration plummet?
It was the combination of going after the socioeconomic status of African Americans brought about by the legacies of slavery. So the ways that poverty worked to make paying the poll tax difficult, very difficult. The way that the lack of education, the lack of quality education made passing the literacy test very, very difficult. It was like a twin pincer motion on the Black electorate.
And were these devices facially race neutral?
Yes, they were not written to say we don't want Black people to vote, but the ways that they used the legacies of slavery targeted African American voters.
And given your research, does a voting law need to be explicitly racist in order to disenfranchise voters?
No, it does not have to say we don't want Black people to vote. You can have facially race neutral laws that do the work of discriminating against Black voters.
And Dr. Anderson, would you consider the poll tax and literacy test to be forms of voter suppression?
Absolutely.
And would you say that they are forms of voter suppression in North Carolina?
They were forms of voter suppression in North Carolina. Absolutely, yes.
Dr. Anderson, how does the history of voter suppression in North Carolina impact your opinion about SB 824?
It shows that there is a pattern of lawmakers looking at Black political power, Black political advocacy, electoral power, and then responding with a series of laws to undercut that Black political power. So SB 824 is in line with that pattern.
Dr. Anderson, how did you come to that opinion?
I came to that opinion by looking at the history of voter suppression in North Carolina. So seeing what happened with the Act to Regulate Elections in 1899, followed by the constitutional amendments for the poll tax, the grandfather clause, and the literacy test that give it this aura of legitimacy, that then looking at the ways that it was implemented, then looking at how when there were judicial challenges, the tweaking of those laws to the tweaking of the literacy test in order to make it judicially palatable, and then seeing how in the 2008 and the 2012 elections, the presidential elections, how you had strong Black voter turnout. And the response was HB 589, which the Fourth Circuit ruled had targeted African Americans with almost surgical precision. And then seeing how coming after that judicial brushback pitch, you get another just so tweak with SB 824, which was to one, the McCrory decision for HB 589 said one of the things was that it was the omnibus feel of this. It was the cumulative effect of all of these measures in HB 589 that was part of the big red flag. So you see with SB 824 pulling voter ID out of that larger law. And you also see where you get these reasonable impediments, which was also part of the McCrory, was in the McCrory dissent, that was put in the SB 824 to as another kind of just so tweak to be able to get it through judicial review.
And Dr. Anderson, you mentioned just so tweaks. What do you mean by that?
I mean these amending a law in a way that shaves off the most egregious components, but leaves the essence of that law in place. So we saw that with the literacy test and the removal of the registrar's caprice from the action of the literacy test.
And Dr. Anderson, do historical patterns matter in analyzing the impetus behind certain laws?
Oh, yes. History matters. One of the things that historians do is we look at issues of change and continuity. And so when there is a pattern and you see that pattern of Black participation, and then you see a wave of laws coming through to undercut that Black political participation, that is a pattern that I have discerned.
And Dr. Anderson, how did the fact that a constitutional amendment preceded SB 824 factor into your analysis?
It fit the pattern that I saw at the turn of the century in the rise of Jim Crow, where there was a law, the 1899 Act to regulate elections, that had in there the poll tax and the literacy test and the grandfather clause. And then you get the election for the constitutional amendments to embed those disfranchising measures into the North Carolina Constitution.
And Dr. Anderson, I'm sorry, go ahead.
And when you look at SB 824, you see HB 589 gets its brushback pitch, saying, you've targeted African Americans with almost surgical precision. And you see the next wave is an election about a law for voter ID, and then to put it into the Constitution. And so that was the pattern that I discerned.
And how does your analysis of the constitutional amendment being passed before this law, how does that affect your conclusions about SB 824?
The constitutional amendment, it does not affect. It does not give it the aura of legitimacy, because that's what we saw happening in the constitutional amendment for 1900.
Thank you, Dr. Anderson. No further questions.
All right, cross-examination, Mr. Thompson. Yes, good afternoon again, Dr. Anderson. I'm David Thompson, and I'll have a few questions for you this afternoon. And I'd ask that you try to answer my questions yes or no, and then your counsel will have the opportunity on redirect to allow you to expand in any way you'd like. So is it fair to say that your work opposes voter ID laws?
Yes, I do oppose voter ID laws.
Is it your opinion that voter ID laws are an example of white rage?
What do you mean by white rage?
Well, I'm gonna, you remember you were deposed, Professor,
Yes.
and you were under oath. Let me play an excerpt of your deposition.
In your opinion, are voter ID laws an example of white rage?
Yes.
Do you stand by that testimony, Professor?
Yes, I do. My question was, were you talking about white rage the way that I define it, or were you talking about it in another way?
I'm using all the terms today in the exact same way you use them in the deposition.
Okay.
And you wrote a book called White Rage, is that right?
That is correct.
And your concept of white rage is that it's about an ideology that's based on white supremacy, is that right?
It is the operationalizing of an idea of a fear of Black political participation and undermining African Americans' access to their civil rights as they advance.
It is an ideology that is based on white supremacy, in your opinion, yes or no?
Objection asked and answered.
Just 1 second, please.
The question wasn't answered, so please go ahead and answer it.
Just pause for 1 second before you answer.
Oh, sorry.
The objection is overruled. Thank you. You may proceed, and now you may answer the question.
White rage is based on a series of ideas that African Americans are second-class citizens and do not have full access to their citizenship rights. And so white rage pulls back and undermines and undercuts African Americans' access to their rights.
I'm really going to ask you today to answer my questions, yes or no, and you'll have an opportunity on redirect to provide all of this context, but I'd like to play you an excerpt of your deposition.
African Americans can have white rage.
Your Honors, I would object to that. This is not providing the full context within her deposition.
Well, play the clip and then you'll see whether it provides the full context, I would suggest.
In the sense of when we look at, for instance, someone like Clarence Thomas, who voted to gut the Voting Rights Act in the Shelby County v. Holder decision. That can happen. And it doesn't mean, because what's also important to understand is that white rage isn't about white people. It is about an ideology that is based on white supremacy, and not all white people are white supremacists.
Do you stand by that testimony?
Your Honor, I still object to this. I'd like a ruling on my objection, please.
The objection is overruled, but let me say, Mr. Thompson, you're apparently attempting to pin the witness down to a yes or no answer and allow the witness then to clear up any misleading answer on redirect. So the witness will be able to certainly answer your question, and it's directed to answer your question, but not necessarily with the response either yes or no. Many times, as you're well aware, giving a simple yes or no response can be misleading because of the way that you phrase the question. So, Ms. Anderson, if giving a simple yes or no response in some way is misleading, please feel free to expound upon that answer and explain it if you deem it necessary to fully answer the question that you're asked. But you are not pinned down, and you're not limited to simply answering any question, yes or no, despite what Mr. Thompson has said to you. Mr. Thompson, you may ask your next question.
And you heard in your deposition sworn testimony just now where you said, quote, "It is about an ideology that is based on white supremacy." You heard that?
Yes,
And you were telling the truth.
yes,
Okay. You believe that Republicans want a white republic, correct?
that is from an op-ed that I wrote, where I am talking about the way that voter suppression has been targeted at African Americans and at Hispanics, um, to recreate this world where an America where whites had inordinate power and access to inordinate disproportionate resources. And so in looking at the policies that you see coming out of uh, many Republicans, it is a way to limit the political voices and influence of American citizens.
And that was the title of your piece in Time magazine was, quote, "Republicans want a white republic," correct?
The author does not write the headlines.
Did you disagree with the headline?
I think that what Republicans want is an America that in many ways, when you're looking at the laws that are being advocated, when you're looking at targeting African Americans with almost surgical precision, that this is trying to recreate an era, a bygone era that we have fought so hard for to rid ourselves of on the Edmund Pettus Bridge.
In your view, SB 824 is an example of white rage, correct?
Yes,
Okay. And do you recall learning at your deposition that one of SB 824's primary sponsors was Senator Joel Ford, an African American?
yes.
Objection, Your Honor.
You
This
know that.
is objection, Your Honor. This is improper impeachment. We actually asked to approach the bench to discuss a matter outside of the presence of the witness.
Give me just 1 second, please. The objection is overruled. Your request to approach the bench is denied at this time.
Thank you, Your Honor.
You did not know when you were preparing your report for this case that one of the primary sponsors of the law at issue was an African American. Is that correct?
That is correct.
But in your opinion, African Americans can have white rage too. Is that right?
White rage, not all whites have white rage, because white rage is about a policies that are put in place to undermine African Americans' advancement. How and who puts those policies in place That is not race dependent. That is not party dependent.
So that's yes, African Americans can have white rage, correct?
Yes,
Okay. And in your view, a judge who votes to uphold a voter ID law is exhibiting white rage. Is that right? Like Clarence Thomas in Shelby County.
yes.
Okay. Do you know, strike that, in reaching your conclusion about SB 824, you concluded that it was born out of North Carolina's prior voter ID law 589. Is that right?
Yes.
But in preparing your report, you did not review the text of HB 589, did you?
No, I did not.
And in preparing your report, you did not even review the text of SB 824, did you?
I reviewed the floor debates for SB 824,
But not the text.
but not the text.
Okay. So you didn't compare the provisions of SB 824 to HB 589, did you?
No, I looked at the McCrory decision and the way the McCrory decision outlined what was in HB 589.
In your view, the only thing the General Assembly could have done to excise the discrimination found in 589 would be to not have a voter ID law. Isn't that right?
That is correct, yes.
So it's your conclusion that any law requiring photo ID that the General Assembly could have passed would be consistent with North Carolina's pattern of voter suppression?
Yes.
Okay. Now, in your report, you discussed some other states' voter ID laws. Did you review the text of any of those laws?
I looked at, when it came to Georgia, I looked at the Department of Justice's review of Georgia's voter ID law, proposed voter ID law. And I looked at some of the text and the discussions from the analyses of Texas's voter ID law, as well as the discussions of Alabama's voter ID law.
Did you look at the text of South Carolina's voter ID law?
No, I did not.
Okay. Are you aware of the fact that a federal court found it had no discriminatory effect?
Yes, I am.
Okay. You would consider historical analysis incomplete if it failed to discuss all relevant available information. Is that right?
I'd like more nuance on that answer that I gave, which is that it's not humanly possible to look at all relevant sources. But what I did in my report in going over almost 150 different sources for this report was to look at a range of sources, primary and secondary, that helped establish the pattern, that revealed the pattern of disfranchisement of Black voters using facially race-neutral policies.
One source of evidence for your report was judicial opinions. Is that right?
That is correct, yes.
And this includes opinions from other states' voter IDs. Is that right?
Yes, it is.
And judicial opinions can be salient to historical arguments like yours, either in undermining or adding to the argument. Is that right?
They provide a source of evidence to review.
But in your review for this case, you don't believe that you saw any evidence that contradicted any of the conclusions in your report. Is that right?
When I looked at those judicial opinions, part of what I'm also very cognizant of is how you had the US Supreme Court in 1898 in the Williams decision say that the poll tax and the literacy test did not violate the 15th Amendment, and how you had the US Supreme Court in the Lassiter decision say that the literacy test did not violate the 15th Amendment. So what we know historically is that we can have judicial opinions that put an aura of sanction around really discriminatory laws that we come to understand looking back how discriminatory those laws were.
You discuss Indiana's voter ID law in your report, is that right?
That is correct.
But you don't cite the United States Supreme Court's decision upholding that law, do you?
No, I did note in my report, though, that the law was upheld.
And it was upheld for being non-discriminatory, is that right?
That is correct.
And the Supreme Court found that it was supported by valid, neutral justifications, is that right?
The Supreme Court ruled that that the state had an interest in election integrity, and that they didn't think that the hurdles were too high. But you know that in the Seventh Circuit, Judge Posner has said he regrets his role in that decision. And Justice Stevens has also said that he regrets his role in that decision.
Well, and he was the author of the plurality, Justice Stevens was, is that right?
That is correct.
And he was one of the leading liberal members of that court, isn't that right?
That is correct.
Were you aware of that decision when you drafted your report?
Yes.
You believe that the Indiana law put voters in a catch-22 because they effectively needed either a birth certificate or a driver's license, is that right?
The catch-22 was that in order to get a birth certificate, you needed to have a driver's license. In order to have a driver's license, you needed a birth certificate. That was the catch-22.
North Carolina's SB 824 doesn't have that catch-22, does it?
Not that I know of, no.
Right. To get the free ID, you just need your name, date of birth, and 4 digits of a social security. Is that right?
As I understand it, yes.
Okay. Now, you've averted earlier this afternoon in our discussion and in your report to Georgia's voter ID law, and you noted that the staff attorneys at the United States Department of Justice had recommended that preclearance be withheld from the 2005 law. Is that right?
That is correct.
While you were writing your report, did you know that the Department of Justice ultimately approved the 2005 Georgia voter ID law as having neither a discriminatory purpose or effect?
I know that the political appointee overruled the staff attorneys at the Department of Justice and cleared that law. That then hit a series of judicial reviews.
Well, actually, were you aware of the fact that the next year in 2006, the Georgia legislature passed a new voter ID law requiring counties to issue voter IDs free of charge?
Yes.
Okay. Did you put that fact in your report?
No, I didn't.
That law was pre-cleared by the Attorney General of the United States. Is that right?
Yes.
Okay. And you're aware that under Section 5 of the Voting Rights Act, the preclearance provision, that a law would not be pre-cleared unless the covered jurisdiction could prove there was neither a discriminatory purpose nor a discriminatory effect. Is that right?
The initial law that Georgia put forth in 2005, the legislature didn't even bother to do a review of the impact. And what the staff attorneys at the Department of Justice found was that Atlanta did not have departments of motor vehicles anywhere near where the Black community lived, and that they were off public transportation lines, that the types of IDs that they were requiring disproportionately African Americans did not have. And so as I'm talking about the patterns here, the pattern is that you have a legislature that is crafting a law that targets African Americans and the legacies of socioeconomic status. and uses those laws as the access to the ballot box.
Respectfully, that answer is totally non-responsive to the question I asked you. The question I asked you was, were you aware that under Section 5 of the Voting Rights Act, a law could not be pre-cleared unless the covered jurisdiction proved that it had neither discriminatory purpose or effect?
Objection.
Yes or no?
Asked
Or
and
you can
answered.
answer
Asked and
yes or no.
answered. Asked and answered.
Was not answered. Were you aware of that?
The objection is overruled. Let me just say, for the record, it's sufficient if you say the word objection once. When a lawyer objects, everyone else stop talking long enough for me to give a ruling. I am conferring, just so you know, I'm conferring with the other two judges each time there is an objection made. So there is a brief pause that is necessary to occur prior to me giving a ruling. If either of you wish to be heard after there is an objection made, then simply say, Your Honor, I'd like to be heard about that. I will certainly give you the opportunity to be heard.
I apologize, Your Honor. For
That's
that.
fine. That's fine. It's the first day, and so some protocols have yet to be fully established, but we're going to do our best to run it smoothly and operationally. But I'll say that the court reporter cannot take down but one person at one time. And so it's important that you not interrupt each other. It's important that you not interrupt the witness. And it's important that you give a pause after there's an objection. Okay? So that
Okay.
objection is overruled. Thank you. You may ask your next question.
Thank you, Your Honors.
The 11th Circuit upheld the 2006 Georgia voter ID law. Were you aware of that when you put together your report?
No.
Okay. In your report, when you're discussing Georgia's law, you say that Black and Hispanic lawmakers, it became clear, had been virtually ignored as white Republicans steamrolled this legislation, HB 244, through the State House. Was Senator Joel Ford in North Carolina virtually ignored as a primary sponsor of SB 824?
No.
Was Senator Ben Clark, who voted for SB 824 on the second reading in the Senate, was he ignored?
I don't know Senator Ben Clark.
Was Senator Don Davis, who voted for SB 824 in its final form, ignored?
I don't know Senator Don Davis.
Are you aware that the General Assembly adopted 7 amendments propounded and sponsored by the Democrats on SB 824?
No, I did not know that.
Were you aware that 38 Democratic representatives voted to approve the inclusion of public assistance IDs under SB 824 and an amendment to that law?
I knew from the floor debates that questions about public assistance ID were salient in that discussion.
Okay, and that 38 Democrats voted in favor of it?
That I did not know.
Okay. In your report, you also discussed Texas's voter ID law that was passed in 2011. Do you recall that?
Yes.
And you referenced the district court decision and the Fifth Circuit decision and the en banc decision. Is that right?
Yes.
And did you review those opinions yourself?
I reviewed sections of those, yes.
Your report doesn't mention that in 2017, the Texas legislature passed a new voter ID law that codifies a reasonable impediment procedure for voters who lack and cannot reasonably obtain a form of voter identification, does it?
No, I do not have that in there.
Okay, and you weren't aware of that fact when you put together your report, is that correct?
That's correct.
Your report also does not cite the Fifth Circuit's 2018 holding that, quote, the Texas legislature passed a law designed to cure all the flaws cited in evidence when the case was first tried, and that the legislature succeeded in its goal. You don't cite that in your report, do you?
No, I don't.
And you weren't aware of that holding either, were you?
No, I wasn't.
So were you not aware that the Texas reasonable impediment process allows voters to state fewer impediments than SB 824?
I'm sorry, I don't understand the question.
I apologize. It was a poorly worded question. So my question is, are you aware of the fact that North Carolina has more bases to state a reasonable impediment than does Texas today?
No, I did not know that.
Okay. In your analysis of Texas, you talked about the district court opinion, but in your analysis of 589, you didn't reference the district court opinion, did you?
No, I didn't. The district court opinion, the one that the Fourth Circuit overturned.
Right, but the Texas district court opinion was overturned and you cited to that, right?
The Texas district court opinion, what the Fifth Circuit did was to say, yeah, this is in the initial piece, yes, this is messed up, but we don't have enough time between now and the election to make the changes. And so it became a question of timing for the Fifth Circuit in terms of what the district court had ruled initially.
You mentioned in your report that in Texas, race and poverty are linked, right?
Yes.
To the extent you attempted to measure the impact of any voter ID law, did you attempt to control for the effect of poverty?
I'm not running statistical analyses that would have that control on that variable, no.
Do you have any evidence to suggest that low-income African-American voters would be less able to present ID than low-income white voters?
No.
When you prepared your report, were you aware that the Fourth Circuit had upheld Virginia's voter ID law?
I don't recall.
When you prepared your report, were you aware that the three-judge court in the District of Columbia had upheld South Carolina's voter ID law?
I don't recall.
Were you aware that the 11th Circuit had upheld Alabama's voter ID law?
I was aware of that, yes.
But your opinion doesn't cite to that, or your report doesn't cite to that opinion, does it?
No, it doesn't. Again, what I was looking at in my report was a pattern of identifying, using laws to target African Americans and to undermine their access to the ballot box, and also being well aware that we have a history of judicial opinions that approve racially discriminatory laws. And so in Alabama, you had the legislators who had recorded themselves on a previous bill talking about how do we depress the Black voter turnout, because all of these Aborigines and these illiterates will get on these HUD finance buses and go to the polls. That, to me, frames an intent.
The opinions that you didn't reference in your report that upheld voter ID, like South Carolina, the Virginia opinion Lee, the Birmingham opinion out of the 11th Circuit, do you believe those judges are committing the same mistake that the United States Supreme Court did in the 1890s with Plessy versus Ferguson?
I believe that we have a pattern here. It is the pattern that led to Shelby County v. Holder. That could say that the racism in the United States is no longer the force that it was. That the that we have all of these Black elected officials and all of these Hispanic elected officials. And so the law itself is a thing of a relic of the past, when in fact racism is strong and viable in the United States. And we do ourselves a disservice by not recognizing that and the impact that it has on our public policy.
The Fourth Circuit concluded with respect to this law, SB 824, that it is, quote, more protective of the right to vote than other states' voter ID laws that courts have approved. And that's true, isn't it?
That I can't speak to.
That Fourth Circuit decision was issued before your report in this case, isn't that right?
A few days before, yes.
Well, I guess 12 days before, is that right?
Early December.
Okay. But you weren't aware of that decision when you signed your report, is that right?
I knew of that decision, yes, when I signed, yes.
Oh, you did know of it and you decided not to include it?
I didn't include it because I was looking historically at a pattern. And the pattern had been established by the review of over 100, almost 150 sources to look historically at the ways that African Americans had been disfranchised.
Did you exclude the Fourth Circuit decision in this on SB 824 and the Fourth Circuit decision in Virginia in Lee and the South Carolina decision and the Alabama decision because it didn't fit the pattern you were trying to identify?
I excluded it because they didn't add to the analysis of the pattern of legislatures using law to figure out race-neutral language to undermine African Americans' access to the ballot box.
That's true for all those 4 cases?
Yes.
Okay. Now, when drafting your report, was it your understanding that voters needed to possess ID to be able to vote under SB 824?
I knew that from the floor debates that there was discussion about what I call an off-ramp, reasonable impediments, that there was discussion about reasonable impediments. Yes.
Okay. And you haven't analyzed the disparate poverty rates in North Carolina, have you?
No, I have not.
Okay. All right. So if we could pull up page 44, Ms. Hardiman, of the professor's report. Just want to pull that up, Professor, just so we can all be looking at the report together. Just give us a moment. Okay. Oh, there's a block quote there. Okay, let's see. So it says in the third paragraph from the top, oops, we're just going to blow it up a little bit. There we go. So in a lame duck special session in December 2018, the NCGA crafted another bill to spell out how the voter ID law would work, which IDs were included or excluded, like public assistance cards, were once again based on data the NCGA collected in 2015 concerning which IDs Black voters were least likely to have. And you're discussing here, the law being discussed is SB 824, is that right?
Yes.
And is it accurate to say that this block quote is the only evidence provided in your report that African American voters disproportionately lack IDs that qualify for voting under SB 824, is that right?
In my report, yes.
Okay, and in preparing your report, you did not review the 2015 data discussed in this block quote yourself, did you?
I did not look at I looked at the McCrory decision that discussed the data.
Okay, and you also did not attempt to verify the statement that the General Assembly included or excluded IDs from SB 824 based on this data, is that right?
That is correct.
Okay. Now, we've talked about how public assistance IDs are now covered by North Carolina law and permit you to fulfill the requirements of SB 824. Did you attempt in preparing your report to confirm what other forms of ID were excluded based on racial considerations?
No, I did not.
In fact, you're not aware of any IDs that the General Assembly excluded from SB 824 because they are mostly held by African Americans, correct?
That is correct.
Okay. If one of your doctoral students lacked any evidence to support one of their conclusions, that's something you'd flag for them, is that right?
I would.
As a historian, do you agree that past discrimination cannot, in the manner of original sin, condemn governmental action that is not itself unlawful?
I'm not sure what your question is.
Well, do you agree with that statement, that past discrimination cannot, in the manner of original sin, condemn governmental action that is not itself unlawful?
I believe that history matters, and that when we see a consistent pattern coursing through our institutions, that we pay attention to that. And so when that original sin of slavery, we keep seeing it manifest itself in policy after policy after policy. We have not eradicated the original sin.
In fact, even if a law had no discriminatory intent, no discriminatory effect, but it still passed after a history of discrimination, you think that it would come under strict scrutiny given that history, is that right?
Given that history, strict scrutiny would be required.
Now, do you agree that to determine whether North Carolina has a history of voter suppression based on race, we need evidence from North Carolina?
Yes.
Just because something is true of Mississippi doesn't make it true of North Carolina necessarily, correct?
Not necessarily.
Unlike states in the South, North Carolina's major trouble spots were not widespread, but concentrated in several counties. Isn't that right?
Concentrated in the east and northeast, in the former areas where there was plantation slavery.
So, again, the major trouble spots were not widespread, but were concentrated in several counties. Is that right?
Concentrated in those counties where you had sizable African American populations and a history of slavery. That's where the problems were.
At the time of the voting rights enactment, the literacy test was a registration requirement in 40 counties in North Carolina. Is that right?
That is correct.
And there was a possibility to bail out or become free and clear of the pre-clearance requirements. Is that right?
Yes, there's a bailout provision in the Voting Rights Act.
And Wake County was bailed out just a few years after the Voting Rights Act. Isn't that right?
That is correct.
And it's one of the most populous counties in North Carolina. Isn't that right?
That is correct.
You didn't mention that in your report, did you?
No, I didn't.
Okay. would acknowledge that African-American voters in North Carolina have been able to make strides since the passage of the Voting Rights Act in 1965. Is that right?
The Voting Rights Act has been instrumental in helping to ease the burdens of disfranchising laws on Black people, yes.
And President Obama won the state of North Carolina in 2008, is that right?
Yes, I believe so.
And he lost Mississippi, Alabama, Georgia that year, did he not?
Yes.
And in 2012, Black registered voters turned out at a 70% rate, exceeding the 68% rate of whites. Isn't that right in North Carolina?
Yes, it is.
Are you aware that the North Carolina legislature today is over 20% African American?
No, I'm not.
But you know that the population of North Carolina is approximately 22% African American, is that right?
Yes.
Okay, as a historian, let's talk about historical methodology. As a historian, you generally prefer to support a historical conclusion with a primary source, is that right?
Generally, for historians, we have a method where we use primary sources and secondary sources.
Okay, but you prefer primary sources if they're accessible, is that right?
You prefer access to primary sources if they're accessible.
Yeah, and a secondary source would essentially be another historian's interpretation of the primary sources, is that right?
That is correct.
And if one of your students relied primarily on another historian's research, that would be a question you would raise about their research, right?
Depending upon the sources and the depth of their primary sources, which primary sources they used, and the way that they deployed them, it becomes a part of our methodology of using primary and secondary sources.
And you absolutely encourage students to search for primary sources for their propositions, is that right?
That is correct.
The primary sources relevant to your report are the judicial records for the state, the legislative records for the state, and the newspapers that are covering what's going on and interviewing the participants. Is that right?
The newspapers that interviewed the participants.
And another relevant source are archival records, like the actual letters that are written back and forth from participants in an event. Is that right?
Yeah, archival records are one of the sources that are used.
You did not use archival records for your report, did you?
I did not. We were in the middle of a pandemic.
Okay, well, aren't some of these online?
Not all of them.
Some are, aren't they?
There's so much that is not digitized and accessible. And
Okay.
so it is, that's why you rely on really strong secondary sources by world-class scholars.
In a I apologize, go ahead, sorry.
Like
Go ahead.
Eric Foner, like Glenda Gilmore, like James Laludis, like J. Morgan Cooser. You rely on them, particularly when access to archival sources is very difficult to get to.
Would you have done your report differently if we weren't in a pandemic and relied more on primary sources?
I would have probably, but the pandemic was real and the shutdown of archives was real. And so using the best sources available was what I did through looking at primary sources that were on databases that I could access, to getting the secondary sources, to getting the court cases, the legislative records, the memoirs, the autobiographies. Those are also primary sources. Pulling together, as I said, almost 150 different sources for a document, a report That is, the report itself is about 40, 45 pages.
When I look at the footnotes to your report, I counted about 34 citations to Professor Lelodis's book, Fragile Democracy. Does that sound about right to you?
I'm not sure about how many times I cited it, but I know that it is a strong book.
And out of the remaining footnotes, I count that 45 cite to, excuse me, books or articles about North Carolina history or recent events in North Carolina. Does that sound about right?
I don't know how many footnotes are citing sources about North Carolina. I didn't count the specific number.
Did you make any effort to account for any bias in these sources?
I'm not sure what you mean by that.
Well, I mean, historical works can have bias in them, right?
Yes, I mean, so I didn't use, for instance, William Dunning's work. Dunning believed that it was from what's called the Dunning School. He was a law professor, not a historian out of Columbia. And he believed that the overthrow of Reconstruction and the rise of Jim Crow was actually a good thing because African Americans were inferior and unable to govern, unable to be part of the body politic. So I did not use Dunning's work.
When did Mr. Dunning write his works, approximately?
He wrote his works, he was big in the 50s.
Did you look for any works from the opposite side of the spectrum, ideologically, in the last 20 years to see if there was another narrative that you needed to take into account?
You mean the narrative that voter IDs or the narrative that there isn't discrimination against Black voters?
The narrative about voter IDs, for example. I'm just wondering if you made an active look to see if there was any voices on the other side.
I did when I was writing my book, One Person, No Vote.
Okay. Now, you don't cite to any of those sources in this report, do you?
No, because what I was tasked to do was to look at the history of disfranchisement, the patterns of disfranchisement of Black voters.
Now, if we look at the literacy test, the poll tax, and the grandfather clause in North Carolina, it massively disenfranchised African American voters in the aftermath of those provisions. Is that right?
That is correct.
And the poll tax prevented African Americans from voting because these voters were less likely to be able to pay the tax. Is that right?
That is correct. They were overwhelmingly sharecroppers.
Yeah, and the bill would come due at a bad time for the sharecroppers. I mean, obviously they didn't have many resources to begin with, but it was also timed to make it particularly punitive. Is that right?
That is correct.
Do voters need to pay anything under SB 824 to get a ID from a county board of elections?
Not that I know of.
And white and Black voters are equally eligible for these free IDs, aren't they?
Perhaps, yes.
When you were preparing your report, you weren't aware whether these IDs can be obtained at one-stop early voting sites, were you?
No, but I know that North Carolina has reduced the number of early voting sites, particularly in counties like Guilford County, which creates its own problems with access.
Be that as it may, whatever level of early voting there is in North Carolina, it's disproportionately used by African Americans. Is that correct?
Early voting is disproportionately used by African Americans.
So providing free IDs at early voting places would disproportionately benefit African Americans. Is that right?
I don't know whether it would disproportionately benefit African Americans, given that the state has reduced the number of early voting sites in those communities.
Do you think it's fair to assume that legislators are presumed to understand the effects of their legislation?
Objection calls for speculation.
Just 1 second. The objection's overruled. Thank you.
Are legislators required to know the effects of the laws that they're passing?
No, that's not my question. I'll just rephrase it. I know there was an objection, so I'll just state it again if I may, which is, do you think it is fair to assume that legislators are presumed to understand the effects of their legislation?
Do I think it's fair to presume that legislators know the effects of the laws that they're passing?
Yes.
Legislators should know the effects of the laws that they're passing.
In your professional opinion as an expert, do you think they typically do?
Typically, history shows that they know what they're doing, and then sometimes there are unintended consequences.
With SB 824, do you think the North Carolina, well, let me strike that. Do you have any reason to believe that Black voters are less likely than white voters to know their personal information required to obtain a free ID from a county board of elections?
I have no information about whether Black voters know their own personal information. I know that one of the difficulties with voter ID laws is the confusion about how do you get the ID, the confusion about what types of IDs you can use. And that confusion creates difficulties in the body politic, creates difficulties in the electorate.
Do you have any evidence to suggest that African Americans are more confused than other groups about the law?
No.
Okay. There's nothing, you referenced the grandfathering clause in the poll tax. There's nothing like that under SB 824, right? Everybody's subjected to it.
With the grandfather clause, that was designed so that poor whites who were illiterate and could not meet the poll tax and the literacy standards would still be able to vote. And that it was also placed in there to take the angst out of white voters that they were being disfranchised as well.
Were African Americans allowed to vote if they could pass, if they failed the literacy test or failed to pay the poll tax?
No.
In all the historical discriminatory laws that you've studied that fit within the pattern you've articulated, do you have any provisions allowing African Americans to vote even if they couldn't meet the law's requirements?
I have seen no provisions that say that African Americans can vote if they don't meet the poll tax or the literacy test, because they were really, those two laws were designed to really, as Jim Big Chief Vardaman said, eliminate the Negro from politics.
Now, voter ID law was part of an omnibus bill, is that right?
That is correct.
And you referenced earlier today Georgia's recent bill. That was an omnibus bill as well, wasn't it?
Yes, it is.
And that's one of the things that made it noxious, is it not?
There are so many pieces of that that made it noxious.
But that's one of them, right?
It's one of them is that they looked at every method that Black voters used to access the ballot box in 2020 and crafted laws to narrow access to the ballot box.
The Fourth Circuit in the McCrory case said that, quote, the sheer number of restrictive provisions in HB 589 distinguishes this case from others, close quote. Isn't that right?
Yes, and that is one of the pieces that I referenced in my direct testimony about the just so tweak. It was the kind of omnibus feel of HB 589 that raised the red flag. And so removing voter ID was what I call a just so tweak, so that it doesn't raise as much concern as having this omnibus bill, the way that what they call the monster bill of HB 589.
Because it has a much smaller impact?
Because it looks like with it's just like the Mississippi plan. The Mississippi plan had a series of hurdles, and it was, if the poll tax doesn't get them, the literacy test will. If the literacy test doesn't get them, then the good character clause will. If the good character clause doesn't get them, then the understanding clause will. And so it's having these series of hurdles that made the Mississippi plan just stand out as this omnibus method for voter suppression. That's what HB 589 had, that omnibus feel to it. So by removing that just so tweak of moving voter ID out of the omnibus feel of it, it lowers the temperature. It lowers the sense of vote electoral danger about what this bill can do.
Because it has a smaller impact. It's just one provision rather than a panoply. Isn't that right?
It is one provision that we have seen repeatedly put in place after Shelby County v. Holder.
And repeatedly upheld. Is that right?
Repeatedly challenged, found discriminatories at sometimes, tweaked to then get to the point where you've got the judiciary saying it's fine. Just like the Lassiter bill. I'm sorry.
Let me interject. I apologize. We had talked at some point that we would stop each day around 4:30 for the purpose of introducing exhibits that were referenced during the day, or perhaps published to the court and that sort of thing. I know, Mr. Mitchell, you actually did introduce an exhibit during your direct examination of the witness, which was fine. But I know that Ms. Riggs earlier in the day referenced several exhibits that were published, and I'm not sure that she ever officially introduced those into evidence. But so I can't remember exactly when we talked about doing that, stopping at 4:30, but it perhaps gives the court a chance to communicate about things coming up or things going on. It also gives a lawyer a chance to communicate. And obviously, if we stop right at 5, then there's no chance for you to give to the clerk. I mean, if we were in a courtroom, you would literally have to give those exhibits to the clerk. So I guess the other thing today is we started back at 1:30. We took an afternoon break around 3, and it's been about an hour and a half since we started back. So it's, if nothing else, time to take another short break. But I say all that just to say, do you, Ms. Riggs or Mr. Mitchell, do you have other exhibits that you want to introduce and make sure that you get those uploaded to the clerks and so forth so that they can have custody of those?
Yes, thank you, Your Honor. Yes, I think we're flexible in how we can address the exhibits issue, but I don't know how much longer Mr. Thompson has. We are able to be flexible in what we do tonight versus the 30 minutes tomorrow night. We do have a large set of joint exhibits to be dealt with, but we were almost anticipating breaking that up. in bite-sized bits.
Okay. Well, to the extent that you have exhibits that were referenced or published today, would you like to go ahead and introduce those into evidence by name and number and then get those transmitted to the clerk's office?
Yes, I think we can do those in probably fewer than 5 minutes. Would you like us to do that and to start on the joint exhibits?
Yes, that's fine. Sure.
Just to clarify then, we're suspending the witness's testimony for the evening?
Yes. And she's free to drop out of the WebEx and be back ready to resume tomorrow morning at 9:30. We'll start each day from this point forward. Well, I say from this point forward, we'll start each day Tuesday, Wednesday, and Thursday at 9:30. As you all recall, the first day of the trial we started at 10, which is today. And then from here on out, Monday through Thursday, we'll start at 9:30. On Fridays, as I mentioned earlier, we'll start at 9 and go to 1 and end for the day. So the schedule from this point forward, Monday through Thursday, will be 9:30 to 5. And the schedule on Fridays will be 9 a.m. to 1 p.m. But thank you, Ms. Anderson, and we'll see you back here tomorrow morning.
Okay, thank you.
Mr. Mitchell, did you have something that you wanted to say?
No, sir. I turned it over to my colleague, Ms. Ricks.
Okay. Ms. Riggs, you can proceed to introduce exhibits and joint exhibits if you want to.
Thank you, Your Honor. I'll deal with our demonstrative exhibits and might seek some advice from the course on that, and then I will turn it over to my colleague Ben Simons for starting to work through the joint exhibits. Your Honor, if it pleases the court, we would move the admission for demonstrative purposes only. The demonstrative exhibits used today marked PDX 1-2 through PDX 1-25. Those were the demonstratives used in the opening.
All right. The PDX 1-2 through PDX 1-25 are received in evidence. And I'll just count on you to transmitting those to the clerk's office.
Thank you, Your Honor. And then in the examination of Elizabeth Holmes, we would move the admission for demonstrative purposes. The demonstrative exhibits marked PDX 2-2 through PDX 2-16.
All right, there being no objection, then PDX 2-2 through 2-16 are received in evidence as demonstrative exhibits.
And to clarify, Your Honors, those demonstratives which we disclosed to legislative defendants and defendants have a cover page PDX whatever -1, but weren't displayed to the court, but it'll just remind you what it is.
All right, thank you.
And with that, I'll turn over to my colleague, Ben Simons, to start talking about the joint exhibits.
All right, Mr. Simons, good afternoon.
Good afternoon, Your Honor. First of all, can Your Honors hear me all right?
I can, yes, sir.
Great, thank you, Your Honor. The parties have previously conferred on a set of joint exhibits that they would like to move into evidence en masse rather than piecemeal. Your Honor, plaintiffs have shared a set of groups of these exhibits with the defendants. And if Your Honor prefers, plaintiffs can begin to move those exhibits in by group or begin discussing whether they should be admitted by group.
Let me have just a second to confer with the other judges about that. But so give me just 1 second, will you?
Certainly, Your Honor.
All right, it looks like there's agreement between the three of us. And that is that if you've conferred with opposing counsel, and all parties in the case agree that an exhibit should come into evidence, then we have no objection to you simply admitting all of those exhibits at one time rather than in blocks or in groups. So that seems to me to make the most sense. But I don't know exactly which exhibits we're talking about. So, but if everyone has agreed that, that an exhibit, and I assume it is because it's a joint exhibit, should be introduced into evidence, then we have no objection at all to you simply admitting all those at one time rather than in groups or sets of groups.
Thank you, Your Honor. That's amenable to plaintiffs. However, plaintiffs would just like to ensure that there's a record of the specific exhibit numbers that are being admitted. So if it is acceptable to Your Honors, rather than read off the exhibit groups, I can just read off the exhibit numbers into the record.
Sure, that's certainly fine. Just, and you're right, preserving the record is important. So, however you want to proceed on that, whether it's just the exhibit numbers and they're specifically marked so that anybody looking at it later will know what is being introduced. If you want to give exhibit numbers plus a brief description of what the exhibit is, that's fine as well. But I'll let you go through that right now.
Thank you, Your Honor. And because that we do not have a contiguous list of joint exhibits that the parties have agreed can be admitted en masse, I'll just read a brief description of the exhibits and then read the applicable exhibit numbers, if that's acceptable.
Okay.
Okay. First, Your Honor, we have a collection of joint exhibits that are State Board of Elections materials regarding election administration and voting. These are JX0001 through 0003, JX0008 through JX0010, JX0019, JX0021, JX0022 through 0024, JX0055, JX0113, JX0349, JX0712, JX0728 through 0745, JX0788 through 0793, JX0796, JX0801, JX0805, JX0810, JX0818 through 0819, JX0842 through JX0849, JX0852, JX0877 through 0878, JX0881 through 0907, JX0916 through JX0920, JX0928 through JX0933, and JX0940. And that is the end of the category of State Board of Election materials, Your Honors.
Okay. I tell you what, I know this is time consuming, but let me repeat that just so that I got all that. And I'm going to leave off the JX parts, okay?
Certainly, Your Honor. And I can do that going forward in the interest of time for the court.
So it's, I'm also going to leave off the zeros in front, if that's okay.
Likewise, Your Honor.
So we're talking about exhibits 1 through 3, 8 through 10, 19, 21, 22 through 24, 55, 113, 349, 712, 728 through 745, 788 through 793, 796, 801, 805, 810, 818 through 819, 842 through 849, 852, 877 through 878, 881 through 907, 916 through 920, 928 through 933, and 940. Did I miss anything?
No, you did not, Your Honor.
Great, I feel good. Sense of accomplishment here at the end of the day.
Happy to help, Your Honor. The next category of joint exhibits that the parties have agreed to admit is State Board of Elections materials pertaining to the no match analysis memos. And this does not include the underlying data sets, just the memos themselves.
All right.
And to clarify, all of these exhibits begin with the prefix JX, and I'm going to eliminate the zeros before each specific number. So these are exhibits 14, 15, 42, 43, 45, 46, 54, and 493.
Okay. Let me repeat those back to you then. 14, 15, 42, 43, 45, 46, 54, and 493.
Yes, 493. That's correct.
Okay.
Thank you, Your Honor. The next category is emails among members of the State Board of Elections. And these are joint exhibits 12, 13, 17, 20, 47 through 49, 53, 56, 57, and 716 through 720.
Okay, then just to repeat those, it's 12, 13, 17, 20, 47 through 49, 53, 56, 57, and 716 through 720.
That's correct, Your Honor.
All right.
The next category of joint exhibits are materials published by state agencies other than the State Board of Elections regarding elections and voting. And these exhibits are 270, 855, and 874.
Okay. These exhibits are materials published by state agencies other than the State Board of Elections regarding voting. And they are 270, 855, and 874.
That's correct, Your Honor.
All right.
The next category of joint exhibits for admission are demographic information published by North Carolina state agencies. And these exhibits are number 713, number 808, number 811, and number 820.
Okay. This is just to repeat then, demographic information published by North Carolina state agencies, did you say?
Yes, that's correct, Your Honor.
And that would be then 713, 808, 811, and 820.
Yes, that's all correct, Your Honor.
All right.
The next, oh, I'm sorry, Your Honor.
Well, I was going to say we're running up close to 5, and I do need some time to do some other things before 5. Is there any particular reason why we could not resume this joint exhibits admission into evidence tomorrow at 4:30?
No, Your Honor, I don't see any reason why we cannot resume this at 4:30 tomorrow.
Okay, let's just stop right there then for the day. And if you'll remember where we were, and we can get into admitting the rest of those at 4:30 tomorrow, if that's okay.
Yes, Your Honor, I'll be able to keep track of that, and I apologize for the sudden loss of ceiling lighting in my office. Apparently, the motion sensors have not been activated in enough time.
I've had that problem myself on occasion. Gotta wait. That's the reason you're just waving your arm.
That's correct, Your Honor. It's quite a modern conundrum I have here.
Well, thank you very much. And again, just remember where we're at tomorrow, and we will resume right where we left off as far as the admission of those joint exhibits and others right there tomorrow. Before we recess for the day, let me go back to I'll call them my point counsel, Ms. Riggs, Mr. Thompson, Mr. Cox. And let me just do a little check with you to make sure that, you know, how are things going, I guess. And let me just, it's sort of a, I guess this is informal, and just wanted to kind of check with you to see how you think the day went. Is there anything that didn't go well? Or are you having any problems? Is there something that we can do better as a court to facilitate your presentation of evidence, or you're making this as easy as can be? Just wanted to reach out to you and after a full day here and say, how you doing?
Thank you, Your Honor.
Go ahead.
That's very kind. We appreciate the court's patience and indulgence with Mrs. Holmes' testimony. Speaking for myself and my team, we think this has gone incredibly well, largely due to your staff and your patience. We may be running a little behind schedule, but hopefully not too much. And I would that probably was to be expected with the learning curve of day one.
Right. Thank you. Mr. Thompson, you have any suggestions or thoughts?
I endorse everything Ms. Riggs just said. Thank you very much for your patience. I apologize again for jumping the gun on objections. I realize there are three of you and you're not sitting next to each other. So it went very well from our perspective, and we'll learn from today tomorrow.
Thank you. Mr. Cox, do you have anything that you'd like to add?
Nothing to add, just impressed that we're having a remote trial and it's going well.
Well, the judges and I talked over lunch, and we also are pleased with the way it's going so far. And we're also extremely impressed with our court personnel, and it really kudos goes out to the Wake County TTA's office, and Kelly Myers is the point lead of that. But this whole process is stressful enough. And so, you know, all anxiety is raised, and you know, so if there's anything we can do to try to lower that down and make it easy for you, then please don't hesitate to let us know. I want it to be, to the extent possible, a pleasurable experience. And after we look at it at the end, we want to say, well, we got our day in court. We were heard. We weren't rushed, and we feel good about the process, and talk about it in a positive light after it all is said and done. So with that, I don't know, Kelly, if you can launch the breakout sessions so that folks can talk, or do I need to, can I do that?
I believe, this is Kelly, Judge Poovey, and I believe you can, but I'm happy to launch them right now as well.
Just go start all breakout sessions?
Yes, sir.
Okay, so.
And Maren, I think Maren's waving her hand. She probably wants to know if court is done, she can, if we're off the record yet, I'm guessing.
Maren, you wish to be heard?
Yes, can I say something off the record?
Yeah, yes, you can.
I just wanted to clarify, generally in court,